I'm here, Your Honor. Thank you.
All right, thanks for coming. All right, let's begin. You know the rules, so let's just start.
Thank you, Your Honor. May it please the court, David Gersten on behalf of appellant. May I begin, Your Honor?
Yes, please do.
Thank you. I'd like to reserve 3 minutes and 57 seconds for rebuttal, just to make
Oh,
sure.
I can keep track of that.
Okay. Well, I'm just taking your lead, Your Honor.
I know you are. Thank you.
Your Honor, this is a case about a trial court order where the trial court chose to ignore binding precedent from this court.
Well, let's talk about that, because the heart of I don't want to cut you off so soon, but you've been doing this a long time. We all have. You're citing cases as precedent that deal with a deed and deed restrictions as to purchases or people in privity with the seller. It doesn't deal with tenants or people in possession through a lease. So there's no precedent on a lease. And if there is, you tell me what case you're referring to.
Sure, Your Honor. Actually, I will. I'll refer to Hayslip. I'll refer to Winn-Dixie versus Dolgen Corp. Dunn versus Barton, which goes back about 150 years. Hagen versus Sable Palm, which is
okay, well, let's start with Hayslip. Here's a distinction I'm seeing in all these cases.
Sure.
I know it says this transaction will be subject to binding arbitration as a special warranty deed, but Kennison sold a home to Hayslip, and then Kennison has an injury, or I mean a defect in the premises, and files a lawsuit and tries to skip arbitration. And the appellate court said, no, not so fast. You're subject to binding arbitration. This essentially was a covenant running with the land, let's say. So it wasn't a lease. It wasn't a landlord-tenant situation that just said, we make a mistake, you have the right to file a lawsuit. It didn't talk about any arbitration in the lease itself. That's where I'm coming from. I need some help on that.
Sure, no problem, Your Honor. Now, I'll take you right to that point. Hayslip, at least the basic premise of Hayslip is that a recorded deed that has an arbitration provision runs with the land. That is what we'll call it a CC&R, condition, covenant, condition, and restriction. So that CC&R runs with the land. That's per Hayslip. Now, Hayslip in particular dealt not with the initial purchaser, but a downstream purchaser. The cases that were cited in Hayslip, I mean, there's a lot of cases in there. It's a unanimous opinion written by Judge Black, uses case law that deals with tenants. So it is certainly a reasonable position that a tenant is a downstream person who is absolutely beholden to the CC&Rs that exist in the original deed. Now,
I jump in?
I'm sorry, Judge, yes.
The cases that was cited to in the Hayslip, and we were fortunate because Judge Valenti was on that panel as well, so I'm sure he's very familiar with the Hayslip opinion. But if you look, and you made reference to the cases that Judge Black cited to, there was a lot of citation for condominium cases. And would you agree that condominium cases is a totally different breed when you're dealing with folks under that? There's a special statute, there's a special thing. Would you at least agree, at least with the condominium type of cases, that is a bit different from the case before us?
Well, actually, Judge, I hate to be disagreeable, but as cited in the brief, we cited to, for example, 718, which is the condominium statute that tells us that people that live in the condominiums, whether they're the owners or tenants, are obligated to follow whatever the condominium restrictions are.
And I appreciate that, but I think what I'm driving at, which was going to be my next point, purchaser, tenant, when you're talking about deeds running with the land, here, the facts of this case is totally different from that. Here, we're dealing with a personal injury action. We're not dealing with any action that deals with the property itself. I mean, if the argument would be made, well, you know, she shouldn't have billed this or shouldn't have billed that, something with a deed, you know, an issue with respect to the actual home, I could appreciate that. But we're dealing with a tenant and we're dealing with a personal injury. And this is where I'm troubled with the fact that, okay, we have, there's an absolute constitutional right to a trial by jury. And in order to waive that right, the person has to agree that they are waiving that right. So we're dealing with a personal injury action. We're not dealing with an issue that's covenant running with the land. Help me out to reconcile your position with Hazlett in this case.
Certainly, Your Honor, I'd be happy to do that. Let's start out with the CC&R that's part of this property. When Your Honors go back and take a look again at the CC&R, it covers personal injury matters concerning the house. That's in the CC&R, and that is what is important in this case. It's not as if it's some contractual issue. So that is in the CC&R. It's specifically stated, and because Florida is a notice state, I would suggest, Your Honor, that everybody is responsible for taking a look at public notice. It's for example, there's no defense that we recognize, and we all learn this in law school. Ignorance of the law is no defense. Ignorance of the public records is no defense. Whether you're a purchaser, whether you're a tenant, either way, you are responsible the minute you get into the state of Florida by plane, boat, or car to access whatever the laws are. And that's just a basic tenet. So if we take the trial court's determination that a tenant does not have to access the public records, that flies in the purpose of the public records law that's been around at least for 70 or 80 years, recognized by every appellate court and the Florida Supreme Court ad nauseum. And this court in particular, and you can go all the way back to the Hagen case from '66, which is a seminal case cited in Winn-Dixie versus Dolgen Corp., that we all have to be responsible for what's in the public records. And you can come into Florida if you have a car to drive to where the public records are located. If you have a computer, if you have a cell phone, you can access the public records. So that's open to all. It's, Judge, quite honestly, it's part of our ordered liberty in the social contract that we're all bound to follow the law. The law in Florida is we are notice and everybody must follow the law. Now, I'm sorry, Your Honor. Go ahead.
And I appreciate that, Ms. Guerin, you're absolutely correct on that. But I think you're jumping, at least I see it, I think you're coming to the conclusion that there's case law supporting the fact that tenants and that in a lease, a personal injury lawsuit on a tenant who's renting a home or renting something falls within that purview. Lead me, and I know you've mentioned Winn-Dixie, you mentioned other cases, but there's really no case out there so far that came to the conclusion or that interpreted the fact that tenant that has been injured, who has leased a home, that tenant is bound by a covenant that's running with the land, and that is not contained, the right of the waiver of arbitration that is not contained in the actual lease. There's no case out there, so I don't want us to conflate saying there's a, that issue has been decided. Just guide me and tell me which case has already indicated that.
Okay, I actually will get there as well. And I will say that the cases, there is not one specific case in a covenant running with the land that was cited in Hayslip. I will suggest that the Supreme Court in Seifert addressed this issue. Now, that was a 1999 case. The trial court, by the way, Seifert was readily available and argued to the Hayslip panel and was cited by the Hayslip panel. And Seifert tells us that, now it's not even a recorded deed, it had to be a contract between the parties, that the provision for arbitration did not specifically state that it covered personal injury. Now, if you note, U.S. Home was the respondent in Seifert. Also, it was the party in Hayslip. So U.S. Home, following the law, and this is why when these cases are so important, when Seifert says you did not cover specifically personal injury, U.S. Home, following exactly what the Supreme Court said, recorded in its deed for all downstream purchasers, tenants, occupants, assigns, you name it. If you read that provision, it covers exactly what Seifert said you had to do. You had to put people on notice that they have to arbitrate personal injury matters that involved the home. Now, in terms of and I want to get to the second, I think your second point, the constitutional issues. Now, the Hayslip case was clearly cognizant of the
And
Constitution.
before we get
Yes.
that, Mr. Gersing, because I had the Cipher case pulled up and I want to double check it.
Sure.
Cipher case was maybe one step removed because we're dealing with the actual purchaser, the husband. This is the case, correct me if I'm wrong. This is the case where the husband, I think, died of carbon, was it monoxide that
Right.
came into the garage. So they were actually the purchaser of that. Here we're dealing with a lease with the tenants. I just want to make that distinction that at least we're not dealing with an all four case with respect to our facts here.
Well, I will suggest, Your Honor, it's the closest that answers your question. And that just has to be, how do you put one on notice? And you do it according to Cipher by making sure that personal injury is covered. Yes, that was a purchaser, but Your Honors, it would be a difficult, I think, road to hoe if you only apply it to purchasers and not downstream assigns or occupants that is specifically mentioned in that covenant. And if anytime you have arbitration, there is a waiver of constitutional rights to a jury trial. That's flat out a statement of fact. You waive it when you arbitrate.
Oh,
When
of course.
Okay, yes.
I guess that goes back to what Judge Valenti was saying, that when you're dealing with arbitration, a waiver of arbitration, you have to have specific notice. And as a purchaser, they're entitled, they usually check through the title search to make sure. But then, which I think goes back to Judge Valenti's question, we're dealing with a lease, a standard lease form that doesn't include anything about arbitration. It makes reference to covenants and, agreement to covenants, but not specifically alerting the person that, hey, based on this lease, you are waiving your right to your constitutional right to a jury trial and agree to arbitrate. That's what I'm concerned.
And I understand, Your Honor, and maybe I can assuage your concern. In Hayslip, the deed in Hayslip made no mention of arbitration either. The deed in Hayslip said subject to conditions, covenants, and restrictions of record. That's basically the same thing that's in the lease of the tenant, subject to CC&Rs of record. And that would at the very least put the tenant on notice that maybe I should check the public records and let me see what's going on here. It is not an unreasonable burden. It's no different for example, Your Honor, let's say, and if we extrapolate out the holding below, and if this court adopts the holding as it applies to tenants, in that situation, it's very possible that a tenant who signs a lease for a year can take their 40-foot, 45-foot RV and park it in the front driveway of their home. And that may violate a CC&R. And if it is the position, if this court adopts the position of the trial court that a tenant does not have to access the public records, they have an absolute defense. Judge Kyle said, I don't have to look at the public records. The Second District Court of Appeal agrees. A tenant does not have to access the public records. It doesn't make sense. And it would be the same in this lease. If we were to take this lease and this was a residential lease, and in the lease, there is reference like we have here, a standard lease, CC&Rs. CC&Rs say only to be used as a residence. And all of a sudden, the tenant decides, you know what, I'm going to use it as a business and I'm going to open up a little coffee house.
You're kind of going far afield with your analogies, though. Let's stick to the facts. Your client was in the attic, walked through the ceiling and said, oh, it looked like a floor. Therefore, the builder's liable. I'm filing a lawsuit. Whether that's preposterous or not is not the issue before us. You want us to treat the deed that incorporates arbitration essentially as a master lease binding on tenants as a subleasee, but it's not a master lease. And Kyle apparently said it's against public policy to require tenants to do all this research. He's not willing to do that. And there's no case saying the tenant has to do all this research on a personal injury matter dealing with the premises, not a defect in something, not a defect, but a violation of the CCR. That's different. Parking the RV, everyone's gonna know there's gonna be a problem. You gotta check with the homeowners, et cetera, et cetera. But there's cats and dogs being try to put in the same cage. And I'm not disagreeing with the trial court. I think the trial court made the best call under the facts. Maybe he's wrong. Maybe we have to wait and see what Hayslip outcome is with the Supreme Court. Maybe they'll reel it in. Maybe it has some loose language in there. I don't know yet, but that would only confirm or deny. And there's a way to maybe help you out. If we were not to rule in your favor, we could maybe write something to say, based upon our belief on Hayslip, but I'm not sure that that's even necessary.
Well, Your Honors, you raise an interesting point. I think just from a practical solution, I'm only suggesting, Your Honors, you are the Second District Court of Appeal, but maybe the appropriate thing to do would be to sit back for a little bit. For the moment, you don't have to issue an opinion at all. Let's see what the Supreme Court says about Hayslip.
Well, the problem with that, and you're almost at the 4-minute, Supreme Court doesn't necessarily have an obligation to write an opinion, even after an oral argument. They might, and it might take a long time. So I don't think that's fair to the parties, but I'm open to suggestions, of course.
Okay,
well, do you want to wrap up? You want to wrap up and say for your 4 minutes? How do you want to do that?
Yeah, sure. What I will do at the moment is, well, I do want to touch on a couple of points. The trial court did make evidentiary findings with no evidentiary basis. And the public policy decision that the trial court made was not based on any case law or any statute whatsoever. I'll save the rest of my time, Your Honor. Thank you very much.
You're down to about 3, but I'm going to round it up to 4 since we kind of hammered you. All right.
Yes, you did. Thank you.
We're good at that. Let's go with Mr. Reed David.
Good morning, Your Honors. May I begin?
Yes, please do.
Thank you, and may it please the court. Jordan Reed David. Today I'm appearing for the appellee Danielle McKenna, who the trial court correctly ruled was entitled to access the courts and ultimately have a jury decide her claims. We're asking this court to affirm.
Why don't you go right to Hayslip?
There is
why there's a difference here, or why
yes. So Hayslip is distinguishable in several respects. First, most prominently, is the nature of the parties of the litigation. As this court has already acknowledged, the Hayslips and Kennisons were purchasers and subsequent purchasers, respectfully. Here, Mrs. McKenna is a residential tenant from an original purchaser. So the privity situation, or better said, the relationships between the parties are not a direct one-for-one. Second, and I think most prominent in my review of Hayslip, are the issues that were actually briefed before the court, well, I should say raised before the trial court that led to this court's decision. There were many distinctions not drawn by the parties or the litigants in Hayslip and kind of assumed to be valid to allow this court to rule. For example, although Hayslip cites numerous commercial leasing cases, there was never an argument made or an acknowledgement of the fact that property law in Florida has many distinctions between residential and commercial law, even in the, especially in the leasing context.
There's no sense in Hayslip saying downstream tenants are binding by the original deed. I mean, it wasn't
before the court. That's right. It was not a fact for the court to consider. I think the better case, and not just because it's controlling out of the Florida Supreme Court, but I think because of what it said in the opinion, is Seifert from '99. Seifert does involve the builder seller and the original purchaser who was unfortunately passed. I agree that the nature of the parties is not identical, but what's really important from Seifert is as it begins to expound upon the nature of mandatory arbitration clauses that arise out of a home, but relate to the remedy of personal injury lawsuits and how they can be litigated, the Supreme Court gave guidance in 2 material respects here. First is when it said, obviously a guest or other person of the Seiferts would not have been subject to the arbitration provisions in that contract. I think that does fit neatly here because Mrs. McKenna is nothing else but another person, not a party to that contract. But more important from Seifert is I think the 4 factors that it required trial courts to consider moving forward, and what I think Judge Kyle did consider moving forward. They are the visibility and the clarity of the purported agreement, the relative strength and knowledge of the parties, the voluntariness of the agreement, and the substantive fairness of the agreement. And the Supreme Court, when it decided the case and gave those 4 factors, said rather than ignore factual variations, courts should use them to craft a balancing test in each case, because of course we're dealing with constitutional concerns. That is what Judge Kyle did. He took the facts before him. He applied the factors. He balanced these factual variations because there is no prior case directly on point and came to the proper conclusion. I think what is definitely not lost on either the parties or this court, but I think has not been properly elevated to the right level is the acknowledgement that the constitutional rights to access courts, have a trial by jury, these are fundamental in nature. And although fundamental rights can be contractually done away with or waived, in the setting of waiver, it has to be specific, knowing, and voluntary. There is no evidence of that in the record before this court. It would be untenable and unjust to suggest that every builder in Florida can, by virtue of slipping in constitutional right language into the original deed, it has waived the constitutional rights of every future Floridian who dares lease that property without being made aware of it. The second issue here, when we're talking about the constitutional nature, is
Let me get back, Mr. Radovid. So in this case, every landlord has every right to change the contents of the lease to add a provision to say that any type of issues, even personal injuries, whatever, shall be referred to arbitration. That could be added on, but the question before us is the lease. In this case, we're dealing with a standard lease, as you said before, Supreme Court of Florida approved lease that has language that makes reference to real covenant, the use of real property in there. And so the question before us, Mr. Gerstein's taking the position that clearly put her on notice for her to check the thing. But the language that's used there is the use of, we're talking about use of the property versus use. So I want you to kind of touch briefly on that issue.
Yes, Your Honor. And my brief really harps on that because I draw the distinction for my client between use restrictions and remedy restrictions. And what this lease in this case mentions in terms of CCRs are use restrictions, which is precisely why Mr. Gerstein's RV hypothetical fails. Mrs. McKenna was told in the lease that there might be restrictions on how you use the property. She was not told that there are restrictions on remedies for any personal injuries that she might have in the property. Basically, the entirety of Chapter 83, the part of it that applies to residential tenancies, is appended to the lease as it's customarily done. There's no mention in any of those statutes about that. There was nothing to put her on notice that her constitutional rights were being waived merely by virtue of executing without a lawyer a Florida Supreme Court form. To your point about use restrictions.
Can you just elaborate a little bit because you confused me there. You said there was a way that she was put on notice as to her use, but not as to the personal injury, but isn't all of that in the covenants? How is one different from the other?
So here's what it comes down to is CCRs run with the land when they affect the use and enjoyment of property. So by virtue of that law, which nobody disputes, the Florida Supreme Court.
I understand that. I'm just going to the notice portion of that. How is she on notice differently between the two? Because you could argue that one shouldn't be effective because of public policy. I can understand that argument, but I'm going strictly to your statement that she was on notice as to one, but not the other. I don't understand that.
What I'm saying is Mr. Gerstein's hypothetical would have better footing because the lease contains language. I forget the paragraph number off top, forgive me, but the one paragraph says use of premises does say that there might be covenants and restrictions affecting the use of this property. What I'm saying is if this was a case involving a tenant's use of the property, Mr. Gerstein and his client might have better footing. But where you're talking about something tangential that doesn't affect the use of the property, it affects a remedy. And not only that, it affects a remedy about a personal injury, not, for example.
So if I understand your argument, then it is the lease that you're saying is controlling, that as Judge Kazan was saying, they could have put this in there and that would have effectively remedied it, but you don't think that in this situation, the language that they used in the lease ties in anything but the use components of the CC&Rs?
Essentially, yes. And especially when we're talking about the implications being waiver of two fundamental rights. Yes, Your Honor. I think the cases that Hayslip cites, which in turn now on appeal, Lennar is relying on, actually help elucidate the critical part of that analysis, which is that all of those cases, without exception, affect use. The Dolan Corp case is, exclusive right to sell groceries. That's how do I use this property to sell groceries? The Dunbar case was, can I use this property to serve alcohol as a bar? There's another case about, can I turn a residential property into a commercial restaurant? All of those things are use. There is no precedent, either statutory or under the case law, for a remedy restriction being read into a lease that doesn't mention it at all about this tangential issue of personal injury. I
So,
do
Mr.
think,
Resident, if I may, and I asked that question of Mr. Gerstein, is there any case out there? And I think Mr. Gerstein's position, he wants us to go one step further and interpret Hazlet or expand the holding of Hazlet to apply to tenants, basically apply that remedies are restricted, coming to the conclusion that it applies to tenants. And this was a bad question. Let me start all over again. Is there any case out there that expands the current law that says that tenants and personal injuries, by virtue of a covenant that's running with the land, are placed on notice that the remedies are restricted in any way?
no is the answer to your question. And there are no bad questions. At least that's what I was told.
I know,
And-
I'm going on. I couldn't even understand it myself. That's
No,
why I had to start.
the immediate answer is no, but more than that, there is a case that forecloses what Lennar is trying to do. I think if we were to boil to its essence, what Lennar is asking this court to do is to stretch the interpretation of a contract, here the special warranty deed. In Seaford, in 1999, the Florida Supreme Court said, and I'm quoting, "It is wrong to stretch contractual interpretations to uphold a purported arbitration agreement where such an agreement would waive constitutional rights." So I think what they want this court to do is something that precedent says it cannot. There are other precedential and statutory reasons why it should not, but I think Seaford says that this court cannot.
Let me just ask you a question then. Do we have the prerogative to appease both sides? I mean, let's say Hayslip gets reversed or interpreted in Mr. Gerstein's favor. How do we cover that prospect without saying he lost this case fair and square? Could we PCO to Hayslip saying, and under a stretch that Hayslip supports your argument because of the reasons you've just read, without having to say all those things, and the PCO would cover him, or take his suggestion to sit on this for a period of time until after the Supreme Court decides Hayslip, which may or may not occur in a reasonable period of time?
I don't think, in all candor, I don't think either of those options are the best options in light of the law. And here's why. I think for starters, the delay aspect, like let's hold off and see. Your Honor's already pointed out, there's no real timetable when the Supreme Court will rule or if they will issue a written opinion. Second to that, my client did challenge their efforts below to stay, which they were successful in this case. And I think an indefinite stay does unnecessarily prejudice my client's ability to litigate her case. But here's the key thing to your first point. I don't think Hayslip controls here at all. I think this court can and should recognize that the nature of the parties to a dispute can be an outcome determinative factor when fashioning the outer limits of its precedent. Hayslip involved a situation more akin to Seifert, which is that a builder seller, subsequent purchaser, maybe even a second subsequent, original purchaser or subsequent purchaser, but nevertheless purchasers. And this court can and should recognize residential tenancies are not the same. There are a host of things I cited in my brief which elaborate on already existing acknowledgements of these distinctions. And so all this court needs to say is that while there are some aspects of these cases that might be interpreted to overlap, at bottom, they are in separate channels. And this court in this case is deciding that the trial court was correct for whichever the reasons it decides to deny the motion to compel arbitration, because in Florida on these particular facts, using this particular lease, there is not a sufficient basis to compel arbitration. Now, I would like to.
So let me just follow up on that. So if the Supreme Court in Hayslip decides to extend Hayslip to support downstream tenants, then he would win his case unless we give him something to come back on and say, you guys messed up this one, fix it. I mean, I don't think we should just ignore his request. I think it's a valid request because the Supreme Court can do whatever they want. They set policy, and the trial judge here didn't want to set policy, so I'm not doing it. There's no case on
No,
point. It's a policy case.
I'm sorry. I don't. So a couple of things. I don't think it's from a practical standpoint and a fairness standpoint, it's persuasive enough to say that the Florida Supreme Court is likely, whenever it issues its opinion in Hayslip, to address tenancies. It wasn't even before the court there. And I think as the court routinely has a proper habit of doing, it limits itself to the facts before the case. I don't think it's going to start.
Yeah, I understand all that. And you're probably right, but it is speculation.
Well, and the second part of it is there is a reason now under the law to draw the distinctions between purchasers and tenants. And so long as this court fashions its holding as Judge Kyle did, along the lines of that distinction and saying we're writing on a clean slate as to residential tenancies, then it's very exceedingly unlikely, speculation or not, that Hayslip would ever have any implication in this case. That being said, I'm not here to tell this court what to decide, only what our position is. I see my time is running short.
You got 5-something.
Okay, I do want to acknowledge a few other points. I think the appellate proceedings, look, this is an important issue. I acknowledge it. I think everything that Mr. Gersten has argued for his client is important to his client, but I think we also need to appreciate some of what is being presented on appeal was not presented below. And I think we need collectively to tread carefully so that any opinion in this case is not decided on an issue that wasn't properly presented. I think notice in the general matter in these cases is important, but for reasons I can't explain, Lennar never even used the word notice in its motion. All of this stuff seems to really come to light the longer this proceeding exists, the more arguments continue to come out about it. I would just exercise caution there. I also think we have to really drill down to see whether or not this clause was ever intended to actually lawfully apply to a tenant. And I think this, the FAA versus Florida arbitration code is an interesting but important analysis not to overlook on that point. So I just wanted to highlight it. You know, you've got two parties to a contract. You've got Lennar and you've got the purchaser. And they're saying, hey, we agree federal law should apply. This court might well be aware, but in federal court, parties can't just agree to subject matter jurisdiction. That's not a thing. But that's what they say. They say federal law applies. But it doesn't because this is interstate. And there's Florida case law I cited on that says the sale of a single residential parcel in the state of Florida is interstate. I cited a second case from a Florida district court that says where a Florida corporation and another Florida corporation have a dealing over land in Florida, it's interstate. So the FAA can't apply. Why does that matter for this court today? It's because that means the Florida code must apply. And the Florida code says the 2012 version, which must apply based on when the deed was executed, says it covers any controversy existing between them or arising thereafter between them. The them in that statute is very clearly the parties to the deed, which would be Lennar and the purchaser, not my client. So you can't take a deed that statutorily is limited to the parties who signed it and take it and apply it to some third party, at least neatly. I think we'll rely on our brief for the rest of it. But if the court has any other questions, I certainly want to make sure that I entertain them. But if there is nothing else, then I would ask this court to affirm the trial court's ruling below. Thank you.
All right, thank you. Mr. Gerstein, I say give you 4 and I will.
Thank you, Judge. I'm going to go quickly, though. I'll cover what was mentioned. I hate to read from cases, but this is a seminal case, nearly 150 years old. First paragraph of Dunn versus Barton. It is the duty of an underlessee to inform himself of the covenants contained in the original lease, for if he enter and take possession, he will be bound by those covenants. Where the restriction upon the manner of using the premises is a covenant running with the land, it is binding upon the estate in the hands of a subtenant. He takes title of the lessee with the limitations and restrictions. Now that is consistent with what we learned in property and law school. You have a bundle of sticks. The owner has a bundle of only transfer the bundle of sticks. Judge Kyle below gave the bundle of sticks plus on top of what the landlord could only convey. The case law says that if you rent for a year, you are a purchaser under the law. So if you're concerned per tenant, the law, and this is a 1-year lease under Chapter 695, plus when Dick leave Road Department, a 66 case out of this court, the second DC, says that if you are a purchaser, if you have a lease for a year, you're a purchaser. So the law considers that. But fast forward from Dunn versus Barton, I hate to read, but if we talk about Seifert, and I'll read quickly, quoting from Seifert, to deprive petitioner of the rights, and we'll say constitutional rights and any other rights that any of your honors are concerned with, simply because she and her husband signed a contract, and this is a recorded deed, not a contract, so it's of record, the contract isn't, which contained an arbitration provision, the language of which provides no indication that tort claims arising under the common law were contemplated or included, would be unjust. Now, that is why in this deeded, recorded covenant to arbitrate, it specifically tells the world it also covers personal injury cases. I mean, it is in black and white.
But if
So-
I may, Mr. Garcia,
Yes,
and if
yes,
you're
Your Honor.
quoting, the quote also goes on to say neither the statutes validating arbitration clauses nor the policy favoring such position should be used as a shield to block a party's access to judicial form in every case. And we're dealing, and I think you are, in my mind, confusing the use of a land with waiving one's constitutional rights. And this is something that I think we need to delve into.
And, Your Honor, that's fine. But again, I go back to every arbitration has that. If you are bound as a tenant, an occupant, or lessee, or an assign, which is covered in this deed, then you are bound. And if you are bound, you arbitrate, and it would be a waiver. Waiver of jury trial is commonplace. I believe all your honors were trial judges. Even in a criminal case, you can waive. And you actually don't get your jury trial unless you ask for it. When you go to the civil case, and this is brought out in the Hayslip briefing, because though not raised specifically in Hayslip, it was raised at the Supreme Court. By the rules of civil procedure that all of you are familiar with, if you don't ask for that inviolate right of a jury trial, you waive it just by not asking for it within the last pleading that is filed, meaning complaint and answer. So waiver is not that drastic in considering waiver in any case, civil or criminal. And indeed, when you arbitrate, you waive. But I just asked the court to please take a look again at Seifert, take a look at the cases that are cited in Hayslip. They are tenant cases. They're peppered with tenant cases. Judge Kazam, I understand it didn't say that this is a tenant dealing with a personal injury case, but as Judge Stargell said, what difference does it make? Policy issues, if you look at 720, if you drill down into section 720, you have mandated by the legislature, who really is the public policy maker of the state of Florida. The
You're
legislature.
kind of out of time, not that I want to cut you short, but you're looking for a PCA, not a PCO. You didn't have a problem with PCO, but you're really just looking for us to affirm the trial court and get this over with, and you move on. You're going to get a jury trial if we affirm. If not, something else might happen.
Well, actually, I'm looking for a reversal, Your Honor.
Okay, then just set me straight. Maybe get my answer.
Yeah.
I thought you were the appellant in this case.
I am the appellant. I'd like to reverse it.
Then I'm okay. I'm still okay.
Judge,
Right.
it happens to me all the time. I'm an old guy. You're younger than I am, but
Not
nonetheless.
about that. All right. Well, since you're out of time, let me thank you both. Did either panel member, since I kind of might have thrown you a curveball there, anyone else have any questions? We'll close this one out. All right. Thank you both, gentlemen. Have a nice day. We're going to move on to the last case.
All right, thank you. Thank you.
Bye-bye.
Stay safe, everybody.
You too. Kurt's